All right, ladies and gentlemen, thank you all very much for your patience. My colleague, Supervisor Cortese, has apparently been unavoidably delayed for just a few more moments and has asked that we go ahead and begin as a committee of the whole. The first item of business is the call to order. We will consider the call to order having been accomplished. We will come back and establish the presence of a quorum once Supervisor Cortese is able to join us. That takes us to item number 2, which is public comment. Mr. Largent, would you like to come forward, please? And as you know, we set aside 3 minutes for public comment, and welcome.
Okay. Good morning, everyone.
Good morning.
Scott Largent, how's everybody doing today? Sorry about that. I brought the binders again. That's when you're really thinking. I went out to an activist that was really involved in the homeless community here 2 or 3 years ago. Kerry Andrew Crittenden, I'm sorry, I always pronounce his name wrong. I was giving him a hand, kind of driving him out. He lives out in Palo Alto. He's kind of in exile out there. He has his homeless encampment out there. His situation is very similar to Victorious' Alexander Victor Mares, and he's also in exile over in Santa Cruz. And myself, being kind of like a civil society activist, I'm basically in exile in my grandma's house. So I try to stay out of the way of the county and the city because of what they've been doing to the community. Joe, I got to experience going out there to Palo Alto. Now, I've watched this a lot on the news, and you start seeing the problems they've had with motor homes and people struggling. And I'm very familiar with the area there. A lot of my grandparents' friends were alumni from Stanford. We used to go there, going to the Stanford games growing up. We're big Cardinal fans. And it was really weird. I go through Mountain View, and we're doing the El Camino. We're driving that because, of course, there was traffic. And I start seeing motorhomes stacked along the El Camino. And you know what it did? It put a smile on my face to know that the city there has the compassion to work with the people that have it the hardest. I mean, they're not gassing their homeless community like the city of San Jose is doing. Okay? It's like night and day the difference. So, Joe, of course, you were the mayor, I believe, of Palo Alto, and of course, that's your district over there. It's like night and day. Over here, they set people up to fail, and they take every single thing that they own. They gas them, okay? The system's rigged, the documentation from the DMV, the temporary operating permits. It's inhumane to treat people like that. You are now teaming up with Mayor Sam Liccardo of San Jose and also Eddie Garcia to start working on this mental health thing and this homeless crisis. Basically, you guys are already gassing them in the city of San Jose. So how do we figure out how to do what Palo Alto's doing? They got it right over there. I thought it would have been the other way around. I thought the people in Palo Alto would have been, hey, get these people out. We don't want them here. They're embracing them, and they're providing them with restrooms. They're helping them fix their motorhomes. They're getting them to clean up their areas. I mean, it is awesome to see that. Here, we tow their stuff, and we don't allow them access to it. Then we add insult to injury, and we beat them in our jails, and then we really take everything from them. Why is it so different, Joe? Why is it so different in your district right there? So I hope you would please try to pay attention to that. I've done the research. I know what the city of San Jose is doing to the homeless community. They're gassing them and taking everything they own. So thank you.
All right, thank you very much. Let me confirm with the clerk that we have no other speakers under public comment. We do not. That will take us to item number 3, which is to approve the consent calendar and changes to the task force's agenda. I think all of that's pretty routine today, so we'll take that action formally, again, once we've established the presence of a quorum. Receive verbal reports from the chairperson and the vice chair today, and the vice chair is making his dramatic entrance even as we speak, but we won't ask yet. We'll come back to that in just a moment after we give him a minute or two to get settled in. Why don't we go instead to item number 5, which is the CEO's verbal report, if any, on federal affairs advocacy task force issues, and see what, if anything, he would like to share with us today.
Thank you, Mr. Chair. I have only a few issues to talk about, which will be explored in more detail as we move through the agenda. Today, well, as of today, the House has 33 days of session scheduled for the rest of the year, and the Senate has 52, which means they don't have very much time to accomplish some significant duties. Probably most significant of all that I think everybody knows about is the Senate confirmation hearing that's going on for Brett Kavanaugh. It's been very raucous over the last 2 days. Pretty clear that the Democrats don't have the votes to stop it. However, it's been a process that's taken quite some time and would anticipate it taking more time, eating up some of the remainder of the session. On more substantive legislative areas, the Farm Bill expires in September, the end of September, and there are two competing bills, one from the Senate, one from the House, that are currently being in committee to negotiate a compromise. There's not a significantly obvious compromise available, so that will be a problem, and we can anticipate lots of lobbying for those issues. The FAA has to have its funding extended by the 30th of September. There doesn't seem to be agreement among the parties about how to do that, and the chairman of the Science and Transportation Committee is pursuing negotiations with the administration, trying to get a deal done before the end of the deadline. And then all in all, September 30th is also the deadline for lawmakers to pass a new spending bill. Both have approved measures. However, as we know, the administration is threatening to veto and shut down the government if they do not include $25 billion for a border wall, which does not seem to be in anybody's to-do list except for the president. So later on in the day, we will have comments from Prime and others to explore more of these details. But I think the summation is lots to do, major issues in the offing, not a whole lot of time to get it done, and the overall problem hanging in the air is the midterms, which are quickly approaching less than 60 days.
Thank you very much. Before we go on to the county council, let me just go back, take care of a couple of housekeeping items. On item number 1, the call to order, we will establish the presence of a quorum, both Supervisor Cortese and Supervisor Simidian present. We have conducted public comment. On item number 3, Supervisor Cortese, if we could ask just for a motion to approve the consent calendar and changes to the task force's agenda, which are none.
So moved.
Thank you so much. Without objection, hearing none, so ordered. We have covered items on item number 4, I had nothing to report at this particular time, but if you wanted to weigh in on anything in particular, Supervisor Cortese, this would give you an opportunity.
Other than reporting late, I'm good. So thank you.
That's all right. We
apologize for that.
No, we understand it's hard to be in 3 places at the same time some days. Then item number 5, we have heard from the county executive, and then that takes us to item number 6, which is to receive the report from the Office of the County Council. Before I ask Mr. Williams to lean in, I do want to ask if those who are on the line could be introduced. Ms. Christian, you want to help us with who's joining us by phone today?
Yes, thank you. We have Angie Melton Buckingham from the Margolin Group. She's based in Washington, D.C., and she'll be talking on the health item on the agenda. Then we also have Aaron Graffey and Rich Mead from Prime Policy Group, the county's federal lobbyist, on the line.
All right. And it was Ms. Graffey who's joined us as well as Mr. Mead, yes?
Yes.
We're both here.
All right, thank you. All right. Then let's turn to Mr. Williams. We have a lot of items on your agenda today, Mr. Williams, because I know we've got a lot of different activities underway, and I'm also going to go back to Ms. Christian because apparently I've moved too quickly.
I'm sorry for the interruption. I believe that Angie Melton Buckingham has a conflict at 11.
All right.
And there had been some conversation about possibly having her do her report before the county council's report, because I think his will be quite lengthy.
And that's not to suggest that he can't be concise. It's just that his report today is
He has a
lengthy.
lot of information to cover. He
right,
is
yeah,
very
thank-
concise, but he has
thank
a
you.
lot
All
of
right.
information to cover.
All right. Ms. Buckingham, are you still with us?
Yes, I am. Hi.
Hi. Well, thank you, and I'm happy to turn to you and see if we can get, I gather this would be item number 7 primarily, Ms. Christian, yes, on our agenda? Okay. So why don't we go ahead and hear that next?
Sure. My name is Angie Melton, and as Danielle said, I work with Bert Margolin. I'm in the D.C. office of the Margolin Group. I know Bert has appeared before your committee both in person and by phone in the past, and he has asked me to do the report today. So I'm going to cover most of the things he's covered in the past with updates to those. I'm going to start with the issue of healthcare reform, which, it's still out there. We still have the Affordable Care Act, but today the court case challenging key parts of the ACA, Texas versus Azar, starting oral arguments. And that is certainly timely considering that the Supreme Court nomination of Brett Kavanaugh is being discussed today as well, because this is a case that could make it up to the Supreme Court, likely will make it up to the Supreme Court depending on what happens at the lower level. That case has red states who sued the administration, except the administration has decided that they will not defend the suit. So some blue states, including California and other attorneys general, are defending the Affordable Care Act. Basics of the case are that because the tax law reduced the individual mandate penalty to 0, then that makes the rest of the ACA unconstitutional because the individual mandate was the basis for the constitutionality in the 2012 case. So that, I say, sets the stage for the fact that this is concerning many congressional Republicans because pre-existing condition coverage is a very popular part of the Affordable Care Act, which would, if the Trump administration and the states that are suing prevail, insurers would no longer be required to cover pre-existing conditions. So they have introduced a piece of legislation in the Senate that would, in their mind, protect pre-existing conditions. But basically what it would do is allow, it would force insurers to continue providing insurance to people with pre-existing conditions, but it doesn't have to necessarily provide coverage for those conditions. So it's questionable whether that issue would actually...
Excuse me, Ms. Melton, excuse the interruption.
Yeah.
Could you say that again? I got, it would do what, but not what?
So it basically would require insurers to let people buy policies, even if they have a pre-existing condition. But it doesn't require them to provide the coverage for those conditions.
Thank you.
You know, the Affordable Care Act had a laundry list of things that insurers had to provide, and this legislation would not continue that laundry list over. It's unclear if this legislation would actually move anywhere. I think it was the Senate Republicans' kind of last gasp to say, oh, we don't know what's going to happen in that court case, but we want to show that we're still supporting our constituents who are concerned. So I bring that up to say that obviously the ACA is an important issue, and the Trump administration, I think, as Bert has discussed in the past, continues to try to find ways to undermine the ACA through regulatory means. There have been the association health plans, the short-term health plan regulation. Recently, the administration cut grants for the ACA Navigator program to help people find insurance, cut from $36 million to $10 million. And Vice President Pence was on the campaign trail for some candidates, I think recently in Wisconsin, and said that if the midterms go well, we'll certainly go back at trying to repeal the ACA. So it's still certainly on the mind, We don't think it's going to happen this Congress, but we'll see how things go after the election. And I think, as Bert has mentioned before, and I would just reiterate, there was this discussion that you take away the individual mandate, then everything's going to explode. But states are finding ways to keep costs down a little bit. Maryland just had a 1332 waiver approved for a reinsurance program that would help them lower rates in the state of Maryland. So states are continuing to support the ACA and find ways to keep the costs down. Costs have not risen as much for 2019 as had been expected. The next thing I want to discuss is 340B, which we know has been a big issue both at the state and federal level. And just before the August recess, there was another hearing in the House Energy and Commerce Committee about 340B. They were, quite contentious. They didn't discuss, they weren't marking up legislation. There was just kind of discussion periodically of pieces of legislation. But since that hearing, a couple of things have happened that make the situation much less likely for 340B legislation to move forward. The first is that Congressman Chris Collins from New York was indicted on insider trading, and he was removed from the House Energy and Commerce Committee in August. And he was one of the most vocal advocates of changes to the 340B program. And since he is now off the committee, staff of many members I've spoken with over the last couple of weeks have said they think that it will not move forward because he was the one who was really pushing for hearings and markups, and now he's no longer part of the committee. The other thing that happened is in late August, the chairs and ranking members of both the House Energy and Commerce Committee and the Senate Health Committee sent a letter to HRSA, which is the body that regulates the 340B program. And they told HRSA, you've come before us for all these hearings, and you keep saying that you need more oversight and you need legislation that gives you more oversight over the 340B program. But our analysis shows that you aren't actually exercising the oversight you have right now. And so it was these congressional leaders basically telling HRSA, you need to actually do the regulations that you're allowed to do. You need to exercise oversight over the pharmaceutical companies, and once you show us that you're doing that, then maybe we can consider further legislation. So those two things together show that Congress seems to be done with the 340B issue for the time being. I'm not going to say definitively because there is going to be what's called the lame duck session after the election, and they can be crazy, and you never know what's going to happen in a lame duck session. But for now, the push to do legislation on 340B seems to have diminished a lot. So I've got a couple more things. One is, I know Bert had mentioned before that there was major opioid legislation passed by the House of Representatives. The Senate has been working to put their package together as well. They've run into a few hiccups over this week as they're talking about what provisions to include and not to include in their legislation. Several different committees have been exploring opioid legislation in the Senate, and they're putting legislation together from lots of small bills, and they're trying to decide what to include, which would then have to pass the Senate and then have to be worked out with the House version. So it doesn't appear that that will be able to come up until the lame duck session. Doesn't seem that they're going to be able to do that before the election. Because as was mentioned earlier, there aren't a lot of days left in this session, but the House actually only has 18 legislative days before the end of September. They only have 18 legislative days before the election. They have 10 legislative days before the end of September. So just a very short time to get stuff done before the election comes. So they're pushing a bunch of stuff to after the election. And then the last thing I wanted to touch on is Title X. As we know, I think people have seen the news that Title X grants were recently awarded with a 7-month cycle instead of the usual 1-year duration. And reported after HHS put out a new set of guidelines for grantees that were really concerning to a lot of people around the country. They thought that this was going to change who got the grants, and that different entities that don't provide comprehensive family planning services were going to be getting grants. And by and large, this cycle of grants, that didn't seem to happen. It was pretty much, in California, Essential Access Health is the grantee, and then they sub-grant to a bunch of different organizations throughout the state. They got the grant as they had in the past, and, throughout the country, there were some Planned Parenthood affiliates that got grants. So it seems like it was a relatively normal grant-making process, except for the fact that it was a 7-month cycle. And the reason for that is that, as we all know, there was a new Title X regulation that was put out by the administration that would make some pretty major changes to the program. And comment period for that regulation closed on July 31st, and about over 500,000 comments were submitted to that regulation. And Amy Clara told me that Santa Clara was one of the commenters, which is great. More commenters, the better. So those new regulations, if they come through as drafted, would require physical and financial separation between Title X services and abortion services, which would basically disqualify Planned Parenthood and other Title X recipients that provide abortion from continuing to participate in Title X, because making that kind of a separation is a very onerous process for an entity like that. And then the other thing they would do is prohibit Title X providers from giving any information, counsel, referrals about abortion as an option, even if that kind of information is requested by their patients. So those are some pretty major changes to the program, and the HHS goal is to get all the comments through, read through all the comments, respond to the comments, put their new regulation out in formal so that it can be effective before this 7-month grant period expires. And then they will put out new guidelines for grantees sometime next spring, and there will be a whole new application round under this new regulatory structure. So that's what is the rationale for changing the amount of time for the grant. And I know that in the past, Bert has spoken about the 1115 waiver renewal. I don't think there's really much new news about that. It's going to be a process that will have to get started as soon as the new administration is, gets started. The only thing I would say about 1115 waivers is it is something that CMS seems to be really interested in. So while it could be a difficult process just because of the relationship between the administration and the state of California, they are very open to doing waivers. So it's just a matter of whether the details can be worked out. So that's my report for today. I don't know if anybody has questions.
Just a couple of quick ones before I go to Supervisor Cortese, my colleague. And you go by Melton, Ms. Melton, just so I have the right name here as I'm calling on.
Yes. Yeah,
Thank you.
My name is Angie Buckingham Melton, but that's a mouthful, so I just say Melton. So that's great.
All right. Thank you so much. Forgive me if I go back to what is almost a constant baseline question for us, which is, so we do not anticipate a frontal assault on the Affordable Care Act between now and Election Day in the either the House or the Senate. Is that a fair statement?
That is a fair statement.
All right. That being said, while we don't anticipate a frontal assault on the Affordable Care Act in a lame duck session, we should just all be mindful of the fact that you never know what happens in a lame duck session. Did I get that part right as well?
Absolutely.
Okay.
Absolutely.
And then the 340B, I was struck, we often wonder whether or not an individual member can have much impact in Congress, and I gather what you're telling us is that absent Mr. Collins, there really isn't that much impetus to move in a significant way on this issue?
To a certain extent. There is, Congressman Bouchon has sponsored a piece of legislation that would put a moratorium on new sites for Hospital 340B, and he is still a very big proponent of changes to the 340B program, but without his cohort, Congressman Collins there, they were the two biggest voices, and so when Congressman Collins is no longer on the committee, and the circumstances in which he had to leave the committee, I think, are making some concerned about the optics, word we use a lot, because he was indicted for insider trading with a medical company, and he has been linked in the past to pharmaceutical and medical companies, and so I think that there's a kind of a concern on the part of the majority. We don't know if we really want to go there right now. But he did have a pretty big impact on the direction the committee was going on this particular issue.
Got it. Thank you. Let me turn to Supervisor Cortese, see if there are any questions at this time. Supervisor?
Just a follow-up question on the Title 10. So what I'm hearing, I think what I'm hearing is that these changes that are contemplated to take effect in spring of 19, calendar year 19, are essentially rulemaking changes that don't require congressional approval? Is that essentially what you're saying? Okay. And so what would be, I'm going to ask you to perhaps speculate just a little bit, if anything, what would be the obstacles once the public comment is done to that rulemaking actually becoming effective? I assume litigation, some kind of effective litigation would be one strategy, but is there anything just in the process itself that you're aware of, politically or otherwise, that could hold up those changes?
Well, one thing that the Trump administration used quite a lot when they came into office was something called the Congressional Review Act, which is a process by which regulations can be kind of pulled back by Congress once they have been promulgated. And if there were to be a change in the majority in Congress, there is the potential, not a huge potential, because it has a 60-vote bar in Congress. For the Congressional Review Act to work, you have to get 60 votes in the Senate. But that's one option if the Democrats were to take control of Congress. The other option is litigation, and I know there are a lot of groups that are contemplating under what grounds they would sue. I think that there's been some conversation with the Attorney General in California about whether California would be part of a suit. There was already a lawsuit under the guidelines, the new Title 10 guidelines, before these grants were made, and the judge at that time said, you haven't been harmed yet because the grants haven't been made. So, I think they're going to have to play out when they can file litigation and what grounds, what harm they can show. So that, I think litigation, the Congressional Review Act are really the only two options. And also, a new administration that puts a new rule into place.
When you say new administration, obviously that presumably wouldn't take effect until 2020. So these are the two near-term, if you want to upset the apple cart before the new rules become effective or concurrent with that, it would be CRA and litigation, is what I'm understanding. Your take is, I'm sure our counsel will probably talk some more about that. Our legal counsel here is very well versed on this. So thank you. Thank you for that explanation. This is exactly the information I was looking for.
Before we move, thank you. Before we move on, let me just ask if the folks at Prime have anything they want to add on the health policy and budget landscape.
The only thing I'd add is that the only other event that happened was the administration did finalize their regulation on the so-called short-term plan. So now, under the Affordable Care Act, insurers can issue plans that are not compliant with the ACA for up to 1 year, and they can be renewed 3 times, so for a 3-year period. So it's a pretty big change. Again, that rule is being challenged in the court, so it may get stopped in the court, but for now, they finalized the rule to allow for those non-compliant plans to be sold.
Got it. All right. I think that now allows us to go back to item number 6. Ms. Christian, does that work for the schedule as far as you know?
Yes, thank you.
All right, thank you. We'll go now to Mr. Williams, who does indeed have a long list today, and that's at my request, Supervisor Cortese, to make sure that we have sort of a brief update on all of the many projects that we've asked the County Counsel's Office to work on the federal front.
So just to begin, I would just point out that we've continued to update our chart of significant litigation regarding federal actions, and many of the items that were just discussed are actually included in that chart, and that's posted as a publicly available attachment. For example, with respect to the ACA case that was discussed, there's a preliminary injunction hearing scheduled in federal district court in Texas on September 10th. And that's one of the many cases that we are closely monitoring. Also, just one quick note, kind of following up on the prior discussion regarding the Congressional Review Act. I think realistically, given the current Congress and current president, that's not, frankly, a likely avenue to overturn a rulemaking from the current administration. It would really require cooperation from the same people that promulgated the rule. So litigation has become really the vehicle in the short run and medium run to challenge administrative actions that are being taken. And as you can see from the chart, virtually every significant rulemaking has been challenged one way or the other. Some of those cases are more meritorious than others, especially challenges to interim rules and other things where the administration has tried to take procedural shortcuts. Those have really run into a lot of trouble in court, and also where the administration has really distorted the underlying statute in its rulemaking. And I think the challenges associated with this short-term insurance provision, short-term now being defined as 3 years, basically blowing a big hole in the ACA, those kinds of things provide good facts to say, wait a minute, this is not a rulemaking that's consistent with the underlying statute. Turning to kind of the updates I was asked to provide, first are some of the cases where the county is a party, just so that everyone kind of knows where we're at in those cases. The first is our challenge to the executive order on sanctuary jurisdictions. This is President Trump's January 2017 order where the county is a party in the case. We obtained a preliminary injunction and then a permanent injunction. That was then appealed to the Ninth Circuit. The Ninth Circuit on August 1st issued an opinion that upheld the permanent injunction as applied in California. It agreed with our interpretation of the executive order, found it unconstitutional. What it did do, though, is vacated the nationwide portion of the injunction and remanded to the district court to make more thorough factual findings regarding the need for kind of nationwide applicability. The record below was very sparse on that point. It actually wasn't an issue that was significantly litigated in the trial court. But while the appeal was pending, it's become kind of a big issue that the federal government has made in cases across the country. The administration's challenging the ability of courts to issue nationwide injunctions. And so that wasn't something that was a focus point before below, and so the Ninth Circuit has basically remanded on that particular point to get a more developed factual record. At this point in the case, the Trump administration can seek a rehearing en banc before the full Ninth Circuit. They have 45 days, so until about the middle of this month, to seek that if they so choose. They also have 90 days to seek review to file a cert petition with the U.S. Supreme Court. It's not clear exactly what they'll do on this particular item, and if they don't seek further appellate review, the case will return to the district court on that specific remand issue. Next case I wanted to talk about is the repeal of the net neutrality rules. Briefing is underway in this case in the District of Columbia Circuit, and the briefing will be completed in November. This is basically a challenge to the Trump administration's repeal of the net neutrality rules. The repeal was adopted by the FCC in December. We actually filed, the County of Santa Clara and the Santa Clara County Central Fire Protection District filed lawsuit challenging that repeal. There were separate lawsuits filed by 22 states and the District of Columbia. There was also a separate lawsuit filed by the California Public Utilities Commission. Those are the public entity lawsuits. Many non-governmental lawsuits were also filed challenging the repeal. The way this particular kind of case works is it's administrative, because it's a appeal of administrative agency action that's based on the record. It's actually direct filed in the circuit court, so it skips the trial court. It's kind of unique in that way. And because of, again, the type of case that it is, all those petitions are consolidated into one single proceeding. And so what happened is all of the dozens of different lawsuits that were filed all got conjoined into one matter regarding the validity of the net neutrality repeal. That all is consolidated in the D.C. Circuit. It's one joint item. And the court actually ordered that all the governmental petitioners together do joint briefing. So there's an opening brief was filed by all the governmental entities together, and an opening brief was filed by all the non-governmental entities together. The federal government will file a response brief that's due October 11th, and then our reply is due November 16th, and then the circuit will, thereafter set oral argument and make a decision. We received a lot of media attention, as many in this room are probably well aware. Included in our opening brief, we actually had made a lot of comments when we submitted comments on the regulatory action, but included in the opening brief was a discussion of the public safety impacts and implications of the net neutrality repeal. That included a declaration in support of our brief from County Fire, which talked about some of the impacts at the Mendocino fire, largest fire in the state's history, and that got picked up and received a considerable amount of publicity, really showing what happens when ISPs, internet service providers, are basically in a position to make decisions based on their economic interests, as we would expect, rather than having to operate on some baseline regulation that takes into account public safety, which, by the way, is a statutory requirement for the FCC in its rulemaking.
Excuse the interruption, Mr. Williams. Supervisor Cortese, I should just mention here, and I know, Mr. Williams, you'll remember this, when we did the initial press conference announcing the litigation that you conducted down here in the plaza, there was a moment when there was a question from a member of the press which, respectfully, I have to say, I didn't think was very clearly articulated, and so it was frustrating for both him and for me, because I was giving what I think he thought were unsatisfactory answers, and he was giving what I thought was an unclear set of questions, so that didn't produce a good outcome. But essentially what I ultimately discerned was he was asking at that time, has the County of Santa Clara ever actually experienced an episode of throttling or blocking or paid prioritization which would adversely affect your ability to provide your services? That's my sort of summary of what the question was attempting to ask. And I believe the answer at the time was no, but we were worried that such a thing could happen. And now, in fact, if the question were asked again and I understood the question, I would be in a position where I'd have to say, yes, absolutely, it has happened, because that's the experience we're talking about.
Yeah, I think the answer at that time was we don't know. And now, obviously, the answer is we do know. I mean, one of the interesting things about throttling is it's often very hard to know. Very hard to know. And so what was quite glaring in the emails that were submitted here is, we had Verizon admitting to throttling, and we had clear, unmistakable evidence of it, because we had firefighters in the field being able to access with their personal devices on the same network much faster speeds than the actual county fire device and the apparatus. And so we actually had what's very, very rare, which is clear and direct evidence of throttling.
Supervisor Cortese, on this point.
I just kind of have a definitional, question in terms of the scope of the original Obama rules, or even just in, what would have been interpretation in terms of defining net neutrality. Some of us who are involved in political activities have had the experience of sort of the equivalent of throttling or blocking in terms of mass email efforts, which are generally about as close to pure political speech as you can get from a constitutional standpoint. But I'm just wondering, it never occurred to me, either for myself or for others that came to me, including at least one proprietary contractor that has to deal with various internet providers who are on the receiving end, and then you get this, I think you know what I'm talking about, you get this situation where there's an uneven set of rules on the other end in terms of who's going to block or who's going to be willing to receive those. I think generally the challenge, the excuse is this could be spam, or we don't know what it is. But generally, again, my experience is very difficult to. It's not a matter of pressing a button or hitting a link and verifying, this is real, or answering one of those things that ask you how many stop signs are there in the window, or there's not a quick way of dealing with it. My question is were the original net neutrality rules intended to deal with those everyday kind of issues with ISPs?
Yeah, I mean, the original kind of net neutrality rules were really targeted at consumer access. So, folks at home, seeking to access internet services, to ensure that internet service providers didn't get to treat the content coming into your home differently based on, for example, if there was a paid arrangement with some provider. Let's say, hypothetically speaking, Amazon did a deal with AT&T, and so all Amazon services would get priority access. They would come in faster. They would come in unblocked, and wouldn't be subject to data caps. But if you wanted to access materials from, say, a mom and pop operation or your local bookstore, that their site would be slowed down. You might hit dial-up speed. You maybe couldn't access it easily at all, or functionality would be limited. Those were the kinds of things that were concerning, and the whole idea behind the net neutrality rules was basically to say, look, we don't want internet service providers deciding what content people can get access to. And of course, that's important for access to government services too. We submitted a pretty lengthy comment letter that the FCC didn't address in the rulemaking, which is one of the issues we've raised, obviously, in the lawsuit. And in that comment letter, we talk about the many, many ways in which people from home need to access government services, whether it's simple things like the agendas and videos for this meeting, to public safety and health concerns like hospitals being able to provide real-time information to our public health department around, epidemic outbreaks and emergency room status, or people accessing emergency alerts or evacuation notices, right? And so the ramifications were pretty widespread. And what the repeal did is it basically no longer classifies internet service providers in the same category as other telecommunications, and essentially leaves it as a free-for-all to the ISPs to decide for themselves what they want to do.
Thank you for that explanation. I guess I'm also just, it sounds like you are possibly implying the same thing, that even previous to this rollback, there were still issues with essentially the enforcement of the net neutrality rules if they were intended to be that broad and sweeping. I can assure you, just as an anecdotal tale that relates directly back into this building, when San Jose was experiencing their floods, we, as probably did other supervisors, used our database to send out alerts, information in terms of to help people in that situation, and some of those involve links and so forth to emergency services. I can assure you that on a sort of haphazard basis, at least that's what it looks like, some of those ISPs on the receiving end just rejected those on the basis that, as we understand it, on the basis, well, we don't know what this is. So I appreciate you answering the question with that much detail, and I've obviously been monitoring the situation as a county supervisor and appreciate President Smidian's leadership leading up to this point on the issue, but I don't think I've had a chance to have that conversation with you, and it's probably good to have it out here so everyone can hear it. Thank you.
Absolutely, and I will say, we in all of these cases, we really look at, where can our involvement provide a unique value-added perspective, which is why, you don't see the county as a party on every single case in this matrix. We obviously don't have the resources to do that. But, where also we think a case is being, where the issues are being presented to the court already, and there's not a lot that we have to say that's different, that's probably not a good place to spend a lot of our resources. We try to be thoughtful about that. This is, I think, a great example of where we were one of the only comments in the nation that really focused on these public safety concerns. And now we actually happen to have some evidence regarding some of these public safety concerns. And so we've provided a distinct and I think a very important perspective, both in front of the FCC, but also now in front of the court, especially since the FCC has actually a federal statutory mandate to consider public safety. So that's yet another example, I think, of where we're trying to be very thoughtful about how we use our resources and make sure that we're raising to the courts issues that maybe other people just haven't focused as much on, but that are very important to have in front of the judges.
Do I gather, excuse the interruption, do I gather that the consolidated cases in toto are now under the heading of Santa Clara County versus?
I think the matter has been restyled something like in net neutrality repeal or something like that.
Got it. All right. Just wanted to know how far out front we were.
But we were the first petition filed actually in the Ninth Circuit, and then the cases were consolidated into our case, but then it was all transferred to the D.C. Circuit.
And did I hear earlier, or do you have any speculation about when the matter might actually be heard, quote unquote?
We don't know, but the briefing will be completed in November.
In November. Thank you again.
The next item I want to talk about is the rescission of the DACA program. There's actually been a lot of different lawsuits here. The county has one of several California-based lawsuits. That county's lawsuit, along with the state of California and several other governmental-related plaintiffs, as well as some individual recipients. We have consolidated proceedings, but different lawsuits that were based here in the Northern District of California. We obtained a nationwide preliminary injunction that restored the DACA program for existing recipients. That's been in place now for quite some time. The federal government has appealed that preliminary injunction and many other related rulings from the trial court, and we are currently waiting for a decision on those appeals from the Ninth Circuit. So oral argument was actually held, briefing was completed, and we're waiting for a decision. A related but different set of cases, or a couple lawsuits that were brought in New York. They're in a similar posture to ours, with appeals pending before the Second Circuit. We have participated as an amicus in the New York cases. They also got preliminary injunctions that look very similar to ours in those cases. Another kind of tranche of DACA cases or lawsuits that were filed in the District of Columbia District Court. Those cases have taken a little bit different twist. There, that judge actually granted summary judgment to the plaintiffs, saying that the rescission violated the APA. So that's common with our cases and the New York cases, but chose a slightly different remedy. Instead of issuing an injunction, the court ordered the rescission vacated. And actually remanded basically to the federal agency for 90 days to come up with a better explanation of what it did. That 90-day period ran. The DHS secretary basically reiterated the same explanation as before. And on August 17th, the district court said that the new memo did not alter its prior analysis, and so it reaffirmed that it was going to vacate the rescission. However, it did partly stay that order, allowing the federal government an opportunity to file an appeal. So if that vacation actually goes through, that would actually allow new eligible individuals to apply for DACA status who had not had it before. So that's a little broader than the injunctions that are in effect in the California and New York cases. The next kind of tranche is actually litigation in the opposite direction. Texas and 6 other states filed a lawsuit seeking to end the DACA program. So this is a lawsuit going, like I said, the other direction. The Texas District Court actually denied the state's motion for preliminary injunction to block the program. So that was a very positive development. The judge did express his view that DACA is unlawful. So he basically said on final decision, he's likely going to rule that the program is unlawful and strike it down. But he denied a preliminary injunction because he believed the harm to the recipients was greater than any harm to the federal government for continuing the program, given how long the states took. In other words, how many years they took to bother to ask for a preliminary injunction. So he kind of said, well, you delayed so long, you're going to have to wait a little longer now for me to rule finally rather than as a preliminary injunction. That's a positive development in the sense that there was concern that there might be conflicting preliminary injunctions, which would necessitate expedited review by higher courts, because obviously the federal government can't comply with conflicting nationwide preliminary injunctions. Also wanted to provide an update on some of the cases where the county has participated as amicus or as monitoring. The first set of cases I was asked to provide an update on are related to the religious and moral exemptions to the Affordable Care Act's contraception mandate. These were interim final rules that were that have been enjoined on a nationwide basis, and there are pending appeals. Essentially, the federal government issued interim final rules. So this is not through the full notice and comment process, that greatly expanded the religious exemption and created a new moral exemption to the Affordable Care Act's contraceptive coverage. The rules, because they were interim final rules, took effect immediately, so not kind of, again, through the normal procedural process for rulemaking. In December, federal courts in California and Pennsylvania issued preliminary injunctions blocking those interim final rules, mostly on the grounds that they didn't follow the appropriate rulemaking process. And currently appeals are pending in both the Ninth Circuit and the Third Circuit. We authored an amicus brief on the Ninth Circuit appeal. The state of Massachusetts also challenged interim final rules. There was a different outcome there. The district court there held that the state lacked standing to sue because the harm it faced was speculative. So that's kind of different from the decisions in the California and Pennsylvania courts. That the state of Massachusetts has appealed to the First Circuit, and that appeal is also pending. On the Muslim travel ban, as most people probably know, after several different iterations, there was a third iteration of the travel ban. The Supreme Court heard the case and issued its decision on June 26th. There was a 5-4 decision that upheld the third version that effectively ended the litigation over the validity of the travel ban itself. However, there are now lawsuits underway that are challenging the administration's failure to meaningfully implement the third iteration's case-by-case waiver process. So one of the things in the third version of the travel ban is there's supposed to be case-by-case waivers, and now that there's some factual information that shows that those waivers aren't really being granted, there's litigation around that, and we're closely monitoring that litigation. Those lawsuits are of course being brought mainly in the name of individuals who've been seeking those waivers, right, the directly affected individuals.
So those are, those again are asking for injunctive relief, those lawsuits typically?
Yes,
Please,
yeah.
this is the facts, so please do this.
Yeah, and I think there's two different aspects. One is, look, your waiver process is a sham, right, which is the kind of more broader claim, and second is, look at the facts of my specific application, I should be getting a waiver.
Got it. Thank you. I
So
understand.
there's both pieces. The other item is the Health and Human Services rule on protecting conscience rights in health care. This is, the federal government has not yet issued a final rule here, but in January, HHS issued a proposed rule that would significantly expand the ability of medical providers to object to providing services on religious and moral grounds. In March, my office submitted a comment opposing the proposed rule. The public comment period closed at the end of March, but we haven't yet seen a final rule, and we're of course closely monitoring that. This could have a significant effect on obviously all healthcare facilities, but including the county's health and hospital system. Finally, I was asked for an update on regulatory and legal action regarding California's vehicle emission standards. A little bit of background here. California has a long-standing waiver under the Clean Air Act that allows it to set and other states to choose to follow its California's own vehicle fuel efficiency standards that are more stringent than federal standards. And by the way, 12 states have actually opted to follow California's lead, so other states can pick between the California standard or the federal standard. However, under the Obama administration, the federal fuel economy standards were actually harmonized with the California standards, so basically there was a nationwide uniform standard. In January of 17, EPA made a final determination to leave those standards in place, but in March of 17, the new EPA announced a reconsideration of those standards, and in April of this year made a new final determination that withdrew the prior final determination and said that they were going to do a new rulemaking process to revise the fuel economy standards for model years 2022 to 2025. California and 17 states, as well as many other different plaintiffs, environmental groups and so forth, have filed lawsuits challenging this April 2018 final determination. The federal government has moved to dismiss these lawsuits, arguing that the April 2018 final determination did not actually set the final revised standards that would be subject to judicial review. On August 24th of this year, the federal government also proposed revised safe and affordable fuel efficient vehicle standards that basically weaken standards for model years 2021 to 2026. And the leading proposed option is basically to freeze all those standards at the 2020 levels for all future years. As part of that, the federal government's proposal would also withdraw California's waiver. And that, of course, would likely engender significant legal challenges. And I believe the Attorney General has already made very clear that the state intends to vigorously challenge any effort to withdraw California's longstanding waiver in that area. We are working in coalition with other entities and closely monitoring those cases as well. So that kind of concludes an update on those specific areas, and happy to answer questions.
Thank you. Supervisor Cortese, anything else? All right, thank you. I think we're good to go. And thank you for covering a lot of ground and in all seriousness, very concisely. We had a long agenda today, but I thought it was important to catch up on a number of these items. All right, we have already taken up item number 7, so I believe that, before we go on, I should just mention and clarify with the County Council, we did have a letter I wanted to acknowledge from Congresswoman Zoe Lofgren regarding the issue of possible CalPERS divestment from certain car manufacturers. Have you seen a copy of that? And if not, I just want to make sure my office gets it to you.
I have not.
All right, well, I just want to make sure. I wanted to sunshine the fact that we have the letter. I think, Ms. Christian, you're familiar with the letter I'm talking about. We'll make sure we'll share it with the County Council as well. All right. That takes us to item number 8, which is to receive a verbal report from the County Executive's Office relating to the fiscal year 2018-2019 federal budget and appropriations process. Ms. Christian, anything there?
Rich Mead from Prime Policy Group is going to provide this report.
All right, Mr. Mead, we're looking forward to having you clarify the federal budget process for us here. So go right to it.
I'm happy to do so, Supervisor. And I should also note, too, that we are also joined by our colleagues, Marty Paoni and Liz Thompson, too. So
thank you all for joining us.
So let me start this report by focusing on the programs of greatest interest to the county, and then I'll turn to where things stand overall in the appropriations process and share our outlook for how this gets resolved for this fiscal year. The first program I want to call out is the Violence Against Women Act, and it's funded about at the same levels in both the House and Senate bills, which have been reported from the Appropriations Committee but not yet have been taken up on the House or Senate floors. And the funding in the House is $493 million, and in the Senate $497.5 million. And those levels are about, I should say, they're slightly above what was provided for that program last year. The numbers for the victims of trafficking have grown actually pretty significantly. That at $100 million in the House, which is more than double last year's funding level, and the Senate provided $85 million, about $40 million above last year. The House bill has a cap on the Office of Victims of Crime at $2.6 billion, which is about almost $2 billion lower than last year. And the Senate cap is at $4.4 billion, about the same as last year. For the Community Development Block Grant Program, the House and Senate have identical funding levels of $3.365 billion, and their transportation and housing and urban development bills. And that bill has been reported out of the committee in the House, and the Senate has included it in one of their so-called minibus appropriation bills. And I'll come back to describe the appropriation buses as part of the overall outlook once they get through some more of your priorities. Also of note, the Home Investment Partnership Program was funded at $1.362 billion, which is the same as last year, and that's the same level in both the House and Senate bills. The BUILD program, the former Tiger grants, were funded at $750 million in the House bill. That's about half of last year's level, and the Senate funded it at $1 billion, about $500 million below last year. There are a couple amendments that are offered on the Senate floor that are worth noting. One amendment that was added by Senator Coons from Delaware and Carper from Delaware that would give projects another year to use the 2012 and 2013 Tiger grant funding that was made available. So it extends and stretches that funding for a year. There's also an amendment offered by Senator Johnson from Wisconsin that would require the FAA to report on the next-gen implementation at commercial airports. The House and Senate were pretty close on the Women's, Infants, and Children program, with the House at $6 billion and the Senate at $6.15 billion. And both of these levels are slightly below the amount from last year. The agriculture appropriations bills with House and Senate include an estimate for what will be spent in the SNAP program. The SNAP program is a mandatory spending program, so the Appropriations Committee doesn't necessarily appropriate monies for the program, but they do include an estimate of what they anticipate will be spent. And their estimate is about nearly $1 billion lower than last year. And there's just a news story that suggests that there may be some reluctance among immigrants for signing up for the program, even if they're eligible and even if they're here on a legal program, there's still some fear that signing up for that benefit perhaps could lead to their deportation was the story. And so there could be that the numbers are lower for that reason. It also could be a reflection on the economy's performance, because the SNAP program is, typically is, counter-cyclical with the economy. When the economy's doing better, that program spends a little less, and when the economy's worse, it spends a little more. So it's hard to know at this point in time to parse out exactly why their estimates are, significantly lower than last year. A little bit on where we are in the process. The Senate has passed 9 appropriations bills, and the Senate has passed 6 of them. The Appropriations Committee has created what we call 3 mini-buses, meaning 3 smaller. So the president last year, after he signed the omnibus appropriations bill, said, I don't ever want to have to sign an omnibus, all the appropriations bill, all in one big chunk. He thought there's too much spending in there. So the Appropriations Committee is trying to do more what they call the so-called regular order. So they've been trying to group these appropriations bills in smaller packages to allow for more expedited consideration of the bills. And so, like I said, there are 3 of these minibus packages outstanding. While it is possible that one of these 3 minibuses could be resolved and sent to the president before September 30th, in all likelihood, Appropriations Committee will probably just shift to write a continuing resolution in September to carry us till after the elections, and then resolve these minibuses and the remaining appropriations after the elections. The other thing, and I'll pause because the next item on the agenda is the Violence Against Women Act reauthorization, and I will pause and come back to that and see if there's any questions or comments about the appropriations process.
Thank you. Let me just go back real quickly. You made passing reference to President Trump expressing displeasure about the spending. Is this you said, and you also said last year, is this I remember in March there was a spending bill about which the president expressed some frustration. Is that the event you're talking about, or are we talking about something earlier in the previous calendar year?
No, you're correct. In March, the president signed the omnibus appropriation, and that was the negotiation to get the funding levels on that bill took a very long time. Is very heated, and is a bipartisan agreement on the funding levels. And Congress sort of exhausted themselves, passed this bill, sent to the president, and then on the Friday morning after Congress had left, the president said, I might veto this. And all of the members of Congress were pretty freaked out, because like, we don't know what we can do if he does veto this. This is really a compromise. And so, yeah, that was the bill that he expressed the frustration over, because it was all the appropriations lumped together.
Got it. And do we have comments from any other members on this item?
Nope, that was pretty thorough.
Thank you. Supervisor Cortese, any comments or questions on this? Let me turn to our staff and ask, as I often do, so as we watch the back and forth in the Washington, D.C. scene, what are the implications for us? How do we manage this? Dr. Smith, do you have any observations? And if not, but I always try and connect the dots in terms of the implications of this. I mean, clearly there's concern about funding levels for a number of programs that we care about, other than monitoring those and weighing in on them to make sure our voice is heard. Any other thoughts you want to share?
Well, our approach from a budgeting and operational perspective has been a little different than previous years when we had questions in mind because of the very volatile and inconsistent message that's coming from the administration. So in the past, we would simply prepare for the worst, hope for the best, but we had some way of at least satisfactorily predicting the worst. Now, predicting the worst is really more like throwing a dart against a dartboard. So we are preparing for what we think might happen that would be negative, realizing that if the administration really goes off the rails, it could be significantly worse. And we are recommending putting aside additional reserves for that possible contingency.
Got it. Thank you. All right, anything else on this item before we move on to item number 9 then?
Yes, Supervisor Smitty, and I forgot to mention there's one other item of interest in the appropriations process, and that is we've briefed staff on the House Labor HHS appropriations bill has what we call a rider policy provision in it that would allow adoption agencies that refuse certain couples from adopting or individuals from adopting to receive federal funding. And there's a lot of controversy surrounding that and concern about the ability of same-sex couples from adopting. And that provision, while it's in the House bill, the Senate has passed off the floor their Labor HHS bill. They do not have the rider, and I would find it highly unlikely that the final bill would include that adoption policy rider.
Thank you. All right, let's go on to item number 9 then, which is to receive the verbal report from the Office of the County Executive relating to the reauthorization of the Violence Against Women Act. Who's going to present on this, Ms. Christian?
I'm going to present some general information, and then if Rich Mead has more to add, that would be great.
Thank you.
Just on quick background, in March, the task force received a report on the Violence Against Women Act. On background, the act was initially put into place in 1994. It was intended to change attitudes toward domestic violence, foster awareness of domestic violence, improve services and provisions for victims, and revise the manner in which the criminal justice system responds to domestic violence and sex crimes. Since its passage, VAWA, which is the acronym that's used, has been modified and reauthorized several times. The most recent reauthorization was approved in 2013, and many grants were authorized through fiscal year 2018, which ends on September 30th, so the act is due for reauthorization. While it has historically enjoyed bipartisan support, there was some partisan struggle over the law in 2013 when it was last reauthorized. At the end of July, Representative Sheila Jackson Lee introduced a bill to reauthorize VAWA for another 5 years. The bill on its introduction had 142 co-sponsors, all members of the minority party. It does not have any members of the majority party as a co-sponsor. I would like to point out that all 4 members of the county's House delegation are co-sponsoring the measure. The bill would increase authorizations for the rape prevention and education program from $50 million to $150 million. It returns sovereignty to tribes to prosecute non-native offenders of sexual assault, trafficking, and child abuse. It adds new definitions, including abuse in later life, alternative justice response, digital services, forced marriage, economic abuse, and technological abuse, and updates the definition of domestic violence. It strengthens public housing protections for survivors, including those seeking housing transfers based on safety concerns. It strengthens privacy protections across state line, online with digital records, and preserves confidentiality upon survivor's death in accordance with their wishes. Has a few other provisions, and it also expands VAWA's ability to respond to sexual harassment. The bill's author is trying to secure additional support and bipartisan sponsors. Had a conversation with the director of the Office of Women's Policy yesterday, and she's involved with an advocacy group that's trying to do some outreach. And we are working on thank you letters to the members of our delegation for co-sponsoring the measure. So at this time, the focus is passing the reauthorization bill by the end of the month. With a full agenda, I don't know what the prospects for that occurring are. Rich might have a little more insight on that, but I'm happy to answer questions.
All right, let me go first back to the folks at Prime, and then we do have a card, excuse me, from one person who wishes to speak. Mr. Mead, anything else on the, go ahead.
Yes, so that the chairman, Senator Grassley, who chairs the Senate Judiciary Committee, has said it's a priority for him to reauthorize the Violence Against Women Act. However, with the committee consumed right now with the confirmation of Justice Kavanaugh, it's probably not likely that his committee will have time to do a reauthorization bill before the end of the month when it expires. Now, there's no consequences in terms of there's no, funding doesn't stop for this program when the authorization for it expires. However, I think politically, I don't think you're going to want to see the actual law lapse. And so what we're probably going to see is a provision in the continuing resolution that simply extends the program for a few months with the hopes of trying to perhaps tackle it during the lame duck session would be my guess.
Okay. Thank you. Mr. Largent, I see we have a card. Excuse me. We have one speaker, and that's Mrs. Scott Largent, who we're going to call up at this time.
It's kind of above my pay grade, but I'm starting to figure out more about the Violence Against Women's Act. I attend all of our domestic violence meetings, all of our subcommittee meetings, and normally you start realizing most of these nonprofits and people in the room, normally they're there to get some type of funding or something. I mean, it's all about the money. We do understand that. I have mentioned in here that these committees are not ran properly. There's no dedicated staff for our domestic violence committee. They don't even have a website. It's all ran out of the Office of Women's Policy. And this is just a disgraceful system we have here in our county. I attend these meetings and it's just like watching, it's like watching grass grow. You wait for things to happen, materialize. It's a shameful process. I know you guys are in damage control mode to try to train these committees now how to handle the public, how to put these agendas out in front of people. It's just very unorganized. So are we in violation of the conditions we have for this type of grant funding? How do we light a fire underneath the county to start getting it right when this money's coming through our door? Because it's really not. And I should have had a one-stop shop to go somewhere to understand what I was dealing with as far as a civil domestic violence restraining order. We need this information that's readily available if you're a victim or if you're a alleged perpetrator of it. We don't have that in our county. Why would we not want to have that in place, and why would we not want to comply with our grant funding? That's what I'm worried about right here. So do we go out in that direction to start lighting a fire underneath the county? You guys didn't make quorum 10 times in a row when I went to those meetings. That's pathetic. That's shameful. People need to start getting fired. It's an obvious thing. I would have just started firing people. Thank you.
Thank you. Let me ask if there are... Forgive me. Thank you. Let me ask if there are any other comments under item number 9. Dr. Smith, I see your light is on. I don't know if that's a... No, as long as that's a remnant. Thank you. Then that will take us to item number 10, which is under advisement from our May meeting. We have a verbal report from the Office of the County Executive related to the presidential executive order entitled, quote, Reducing Poverty in America by Promoting Opportunity and Economic Mobility, end quote. Ms. Christian?
Yes, so the executive order was released by President Trump in the early part of April of 2018. It ordered several federal departments to review their public assistance programs, such as food stamps, housing assistance, and Medicaid, and propose new regulatory or policy changes to the way benefits or services are provided to families and individuals. It called on the agencies to strengthen work requirements, eliminate or consolidate federal programs that are duplicative or ineffective, and give states more flexibility in administering welfare programs. It further directed the secretaries of a variety of agencies to propose within 90 days of the executive order regulatory or policy changes that adhere to 9 principles of economic mobility, which were outlined in the executive order. The executive order also highlighted public charge issues. Public charges meaning an individual who is likely to become primarily dependent on the government for subsistence, as demonstrated by either the receipt of public cash assistance for income or institutionalization for long-term care at government expense. The government currently does not factor in other non-cash assistance, such as health or nutrition benefits, for public charge purposes. An individual who is likely at any time to become a public charge is under immigration law, inadmissible to the United States and ineligible to become a legal permanent resident. In Rich Mead's presentation, he made a reference to a lower estimate of costs for food stamps, and there's a theory that perhaps non-citizens, undocumented individuals are not applying for the program because they're afraid that it would jeopardize their immigration status. And the public charge issue factors into that. In February, earlier this year, a leaked version of a rule being crafted by the Department of Homeland Security indicated that the Trump administration is considering making a long list of government benefits and services part of the public charge determinations, including food stamps, the SNAP program. At this time, there have not been any regulations that have been proposed. The 90 days have passed, but we're still waiting to see what could come out other than the leaked version of a rule. The Office of Immigrant Relations has been working with County Council to be prepared to respond to a proposed rule on public charge if it's released. And as far as the other issues, we're kind of in a wait and see and be prepared to respond if something is released. On the legislative front, the House-passed Farm Bill includes work requirements in the Supplemental Nutrition Assistance Program, SNAP, food stamps. The Senate Farm Bill does not include the same requirements. And as mentioned in Dr. Smith's report, the two houses are trying to consolidate the bills and come up with a compromise that will pass both chambers. The House requirements would require adults who receive food assistance to work 20 hours per week, enroll in job training, or not receive assistance benefits. And with that, I'm happy to answer any questions.
Is Mr. Mead going to add to this, or no? Is this?
The only thing I have to add to that report, a very good report, is that we've not seen anything either. The only thing that development we've seen is that we did notice there was a lawsuit filed against the executive order. So there's already set in motion some legal actions against possible further actions by these agencies.
I guess what I'd like to ask both of you, starting with Mr. Mead, is what's the story behind the story here? When we heard about these work requirement issues from Mr. Margolin, I probed a little Supervisor Cortese and the Health and Hospital Committee, because it was my understanding that there were already work requirements in place in at least some of these programs. And if I recall correctly, it was a question really of expanding the work requirements, but largely to folks who probably would ultimately not be obliged by virtue of some criteria to participate. So what's really going on here, Mr. Mead? Let's see if we can put the question just that bluntly.
So I would say what's sort of going on is that I think that the desire of this administration to advance work requirements is not waned at all. However, I think they're reeling a little bit because when they approved the Kentucky work requirement for their Medicaid program, that got struck down in the courts. And I think the Trump administration realized that their approval of that work requirement wasn't going to stand up in the courts, and therefore they had to sort of double back and try to figure out different ways to do this that will stand up in the courts. And I think that successful challenge of the Kentucky work requirements, I think, has just given pause throughout the system. So I think they're going to try and not go forward with anything that could be struck down by other courts or other programs. So I think that's just given a little pause throughout the administration. I don't think they're taking a step back necessarily. I think they're just taking their time and trying to be a little bit more careful in how they proceed on this front.
Is the goal, in your observation or understanding that this requires a little bit of the reading of the tea leaves, is the goal really to get more people who receive the benefits at work, or is the goal to try and minimize the number of people who jump through whatever hoops are required? Is the goal to pursue this because it's got a political resonance? I mean, I think it's, if you asked 100 people, should able-bodied people work if they can work in order to receive benefits, I suspect most of them would say, well, that sounds like a fairly common sense notion. And so I guess let me stop there and see what your reaction to that is.
I say this not to defend the Trump administration in any way, shape, or form, but rather maybe just share what their thinking is on this program. I think their thinking is that if somebody has access to the Medicaid program and therefore has their health insurance covered, there's not as much incentive for them to go out and find work. And we've heard from a number of employers about workforce shortages in certain areas of the country, and so I think the thinking is, you can sort of solve that workforce problem by tightening the roles on these government programs and sort of forcing some of these people out in the workforce. Now, whether or not that is true and would happen, that's a whole different story. But I think that's part of their thinking of, let's not only make these programs more efficient, like you said. I don't think there's objection in principle to the able-bodied person should be, if they can work, should work, but the devil's in the details. So one of the criticisms of, for example, the Kentucky work requirements in our Medicaid was that it didn't sufficiently protect, like, for example, those people who can't work because they are caring for either a parent or a child or somebody who needs their sort of full-time care. And so making sure those protections are in place, that yes, they're able-bodied, but there are other reasons why they can't work or can't work full-time. And so that's where the challenge of implementing these kinds of requirements is.
Thanks very much. Supervisor Cortese, anything else on this item? All right, if not, we'll go to our final item then, and that is item number 11, which is to receive a verbal report from the CEO's office relating to the potential privacy and data security issues posed by the online administration of the 2020 census. And I want to acknowledge and thank Supervisor Chavez for raising this issue. Supervisor Cortese, you may remember this was at a meeting of our full board of supervisors, and it was one of those things, once it was said out loud, I thought, of course, if we're going to have a significant use of online systems to conduct the census in a way that perhaps hasn't been done before, what are the privacy and data security issues? So, Ms. Christian, I see you've got a new partner there at the table with you. Why don't you lead us through this, please?
Yeah. Thank you. Mike Shapiro, the county's chief privacy officer, is going to provide some information, and if there's more that I can add or that Prime Policy can add after his information, we'll take it from there.
Thank you. And I would just say, if we could please start with at least some indication of, it would be helpful to me at least to know, so what is the use or anticipated use of online systems that's coming our way before we delve into what challenges that may or may not present? Mr. Shapiro, welcome.
Sure, thank you. And to give you a little bit of background that you requested, previously census had been conducted typically, as many may know, through paper forms, and responses could also be provided by telephone. Starting in 2020, the census wants to roll out the online administration to be able to collect responses. Their reasoning for it is that it will cost less and it will be more efficient for them to process results. However, there are concerns that are raised now. Whenever you have new methods of data collection, it can also create new privacy risks that hadn't been experienced before. So right now, what the census plans on doing is they plan on sending out unique census IDs to 80% of the population, and then 20% will receive the standard paper forms. However, those 20%...
Excuse the interruption already.
Yes.
I apologize, but send out unique IDs. All right, so Supervisor Cortese and I are sitting at our homes. We got our feet up. We're reading our board packets. How does this unique ID come to us?
So that'll be received in the mail to every household in the country. Or at least that's the attempt.
All right.
Yeah.
And then?
And so then other 20% of the population will receive the paper forms that are typically sent out to people as in previous census surveys. However, they will also be given a unique ID and be encouraged to respond online as well.
So if we've received the unique ID in the mail, the letter is going to say, "Dear sir or madam, dear friend, here's your unique ID." And what are we being asked to then do with our unique ID?
Then users will be asked to go online to the Census Bureau's website. They'll be given a secure web address where they can go on, provide that unique ID, some basic information in order to get into their particular survey. And then they'll fill out the information in their survey and then submit that to the Census Bureau. So they'll be given basic instructions on how to do that, as well as contact information if they have difficulties understanding how to go through that process and to get assistance.
The reason I'm pausing before I ask a follow-up question is
Sure.
I'm just remembering the rollout challenges with the Affordable Care Act, and that alone is giving me pause. But let's assume all goes well, and Supervisor Cortese, if I can keep pulling you into the mix, he and I each get our unique identifiers. We go online at home, and we participate, and we find that the system is one that we can manage to navigate, and we've done our duty. Well, what then are the privacy and data security risks in your at least initial assessment, understanding that we haven't had a lot of time to think about this yet?
Sure, understand. And so some of the risks that we've generally been able to come up with so far are the risk of having those IDs stolen in some way. And then there's another risk that people can actually respond online even without an ID. It's called a non-response ID submission. And so there's a couple of risks with this. First of all, with stolen IDs, there's a concern that people may go around, individuals or organizations who have an interest in doing so and causing a disruption, may go and actually, go into mailboxes and take out those personal IDs and then use that to file false submission reports to the Census Bureau. Some of the reasons for that, as well as using the non-response ID, are a couple. There's a couple of methods that can be used to do that, and then we'll also talk a little bit about why that would need to be done. So one of the concerns about how that may actually unfold is that there may be organizations that are set up to offer a service to people, namely to marginalized communities who may not have internet access, who may not have computers or smartphones with web access, that they may offer a service to those individuals and say, we will submit your census for you. We'll work with you to submit that. We'll go ahead and take care of that. Just give us your ID and we'll walk you through the process. How that can end up badly is that information may actually not be sent to the Census Bureau at all, or worse yet, they may actually file a census survey for them, but instead of counting them as, say, a family of 5, they may only count them as a household of 1 or 2. So they're going to have an undercounting problem. There's also motivation for overcounting. So if there's a need for certain populations or districts that they want to bolster the population, they may submit a census survey that increases the number of people that are living in that household. So those are some of the ways, the methods that this type of privacy concern can actually impact sort of the validity of the information, as well as the personal information that's given in a census survey itself. Some of the reasons why this may occur are a few. So considering the current political environment, considering sort of the impact that this has on congressional districting, on budgetary allocations, there can be a need to overcount certain populations or undercount certain populations to either draw funds away from or add to certain districts. And as a real-life example, and this is actually very recent, and I want to bring this up because this isn't something that's an overblown argument or something that's hypothetical. In our last census survey in 2010, which is very recent, we actually had a problem where the African American community was undercounted by 2.1%, the Hispanic community by 1.5%. Whites were overcounted by 0.8%. So this kind of drives home why certain organizations or entities may try to infiltrate, may try to use those IDs of people to undercount or overcount for certain reasons or motivations that they may have. Some of the other issues that we have, and this is what goes to the Census Bureau's way to try to thwart that or to try to deal with that, and that's to verify the identity of individuals who respond to surveys. So if you use the non-ID response method, or even if you use a regular unique ID response method but you haven't filled out all the questions, the Census Bureau will actually go back through administrative records to try to verify that information and verify identity. Administrative records are considered records from other government entities such as the IRS, the Social Services Agency, CMS, and so on, in order to try to corroborate the information that they have. So they work, for instance, like with the U.S. Postal Service to try to have valid address information, which makes sense. However, there can be issues with the validity of that information even from other government institutions. So if they happen to have erroneous information or out-of-date information, or if that information is unavailable, they may have difficulties even in those instances to try to verify identity. They have mentioned, the Census Bureau has stated that they may also go to third parties to try to corroborate information as well. Haven't gotten the full extent on what third parties that they may use or the depth in which they may use that, but it's certainly a concern about how much information they may pull and bring into the census database. And we'll talk a little bit later about access to that database, which is more of a security concern if there's unauthorized access to that database, considering the extra breadth of information that they're now going to have. So those are some of the issues there with the reliance on the administrative records. And if they get this wrong, or even a few cases of it wrong, what it can do is it can sow extra discord and public trust in our government institutions. Right now, as many of you may know, there's already significant distrust within marginalized communities. For instance, our immigrant community that is certainly worried about the census and being able to trust that the census will be administered correctly, considering that there's been an immigration question that was added. There's a lot of debate about it. And so the concern, regardless, is that there's a lack of trust in how this may be administered and how information may be shared with other government entities. Now, census employees are sworn to protect the confidence and the confidentiality of the information that they receive for their life. They're sworn an oath to that. However, there's always a concern that there may be a bad actor that could be within there, or that there may be somebody that hacks into the system and is able to pull out that information. Regardless, I think the problem is that there is distrust with a lot of our public institutions and with the census and the current political administration on how the census may be administered. And considering that it's online administration can basically expand those problems exponentially compared to receiving it from a paper-based forms, it takes that distrust and it also exponentially expands that as well. So, and again, you may think that, well, the Census Bureau is not allowed to share that information with the IRS, with ICE, with the FBI or other entities. And that's true. Legally, they are not allowed to share that data that they receive. But two things. First of all, the public may not necessarily know that. They may not be communicated very well. The Census Bureau has tried to publish on their website and through other entities that they will not share that information with other government organizations. However, as a real-life example, again, the Census Bureau, and this law has been in place for a while. Taking the 1930 and the 1940 census results, they provided not personal level information to the FBI, but they did provide aggregated information to the FBI about communities that had high density populations of individuals with Japanese descent. Taking that information, the FBI targeted their efforts and went into those neighborhoods to basically round up people and detain them and put them into internment camps around the World War II era. So these are actually real concerns that even though the Census Bureau didn't give personally identifiable information at the individual level to another government entity, they gave aggregated data which really focused in on certain marginalized communities and vulnerable communities in this case. And that they used that for pretty despicable purposes. And the Census Bureau, although they have since apologized for that, the results were nonetheless pretty impactful and pretty detrimental to those families in those communities of Japanese descent at that time. And I could see where our immigrant communities would be similarly concerned today. And considering our political environment, I think those concerns are pretty real.
Let me just interrupt with a very basic threshold question. The, quote, citizenship question that we are anticipating for the first time sometime, is, as far as we know, is it a straightforward question? Are you a citizen of the United States of America?
So it's split up a little bit. It says, are you a citizen or not? Then it says, yes, I'm a citizen who's born in the United States. And then there's, yes, I am a naturalized citizen. So there's a few options. And then there's finally at the bottom that says, no, I am not a U.S. citizen.
Do we know whether or not the census database has ever been successfully hacked in the past?
We don't have any information on whether it's been hacked or not. Of course, the Census Bureau coming online and really expanding its electronic operations is relatively recent. Even in 2010, they collect information through paper forms. They scanned it in. They did have that in their database, but there's been no indication that that has been hacked successfully. But that's not necessarily an indication of what may happen in the future, especially considering that that was 8 years ago and a bit of a different world when we take a look at the hacking community today.
Yeah, I'm just, part of the reason, on the one hand, here I go. on the one hand, I don't want to be paranoid. On the other hand, I'm mindful of the breach at the Office of Personnel Management, I believe it was, where 20 million records were compromised, including folks who were accessed classified information and whose personnel files were, as I recall and understood at the time, compromised. The obvious concern is the ability of someone to access information unlawfully that essentially identifies every non-citizen and attached to a name and an address. Yes.
Yeah, and the census ID as well. And I would say that that particular concern isn't unwarranted. Although the census claims...
Sorry, is or isn't unwarranted?
Isn't unwarranted. I would agree with it. And that's a couple of things. The census mentions that they have performed NIST-compliant security assessments. Nonetheless, there have been other organizations that have performed those assessments that have still gotten hacked into. And so a couple of the concerns is more security related are regarding phishing attacks, not only on users to try to, for instance, create a false website, have users submit their information to a website that looks like the Census Bureau's website but is in fact illegitimate. The other concern is that a phishing attack could be levied against Census Bureau workers themselves, the employees who may enter their credentials or may provide access to the network without them even knowing it, and a virus could be uploaded through the Census Bureau network in that way to obtain personal information.
All right. Did I cut off your report, or were you just...
There was just one other thing
Please.
that I wanted to mention, and this kind of, I think, adds to your concern as well about the database security, as well as how this is administered. Because of budget shortfalls, the Census Bureau claims that they were not able to perform full field test of their census operations. There were supposed to be 3 field tests that were conducted. There's only been one. It was supposed to actually go out to 700,000 households within Providence, Rhode Island, West Virginia, and Washington State. However, due to those constraints, instead of those 700,000 households, which there could be one person in a household, or 4 or 5, which could be millions of people, instead it is only going to Providence, Rhode Island with 275 households. So I'm not sure Providence, Rhode Island is representative of the different types of communities we have around this nation, but I would suggest that it could cause some concerns in the reality of that test and the results, how valid that they may be. It's also going to raise concerns whether the privacy risks that have been encountered through that one particular test, if they will have enough time to remediate that, because they won't be able to do another test. So they're going to have to make those fixes and then go live and hope that it's worked. And so I think between those concerns of the privacy issues raised with that, as well as the security issues, if they get into that database, how they can patch that up in time, certainly create cause for concern for the census so far.
Thank you very much. Supervisor Cortez, I have one more question, but I want to defer to you for the moment and see if you've got other questions, because I have a kind of a closing question.
Appreciate just an quick opportunity. I have, unfortunately, to depart for a noon engagement, so it's one of those days today. I know that the question has been the naturalization and immigration questions have been asked in the past. Just from my own genealogical research, you can go back and pick that up on microfiche on past censuses. Although not having lived in those times, and just knowing what I know from general history, it's never been done during a time when there was at least this perceived oppression, what we would call actual oppression here in Santa Clara County, but at least perceived oppression of people based on immigration status. It's a little different when Ellis Island is operating and there's perceived to be an unbroken immigration system, to gather that kind of information. I think that's, when it was done in the past, more or less. I do think there's a big issue in terms of the phishing kind of expedition, so to speak. But I also think that given the nature of this database, where the information ultimately wants to be very public at some point anyway, it's the nature of it. We want it to be very public at some point anyway, so we know what's up, is sort of a less of an issue in terms of those kind of privacy issues, but these issues about hacking and security. And I'm glad you put, both of them on the agenda. This security issue really seems to me to be not only where we may be most vulnerable as a county, state, and country, but where somebody for this kind of database would be just as well off to go in and scramble the information with a virus and do that, perhaps even more than once, so that essentially everyone knows that none of the information is any good. And what we do know is that we have a larger population, but nobody's able to determine what that larger population is at all and what the breakdown is at all, because we've had this viral attack or repeated viral attacks, in which case, those who are nefarious or who want to make sure that there's no sort of upgrade or augmentation in government funding win just because of the delay. Well, it looks like it's going to be a year or 18 months or 2 years now before we actually get clean data. Therefore, we can't dole out money, right? We can't dole out money except based on what the 2010 census already told us. So I just think that's, I don't want to sound like I have a terrorist mind or something, but I think that kind of almost terrorist attack that just says, why don't we just scramble everything and keep it as scrambled as long as we possibly can? If what we're trying to do is keep people from utilizing accurate, fresh information. So I don't know what you think about that, but thank you for giving me a chance to speak.
Yeah, I would agree. The malware attack that you're talking about, whether it's through scrambling data, we've seen that even with ransomware, that will unscramble it only if you pay the certain ransom. But certainly that may be for individuals that want to sow discord within our country, and I think we've seen pretty good examples of that. So considering that they are NIST compliant, they do have at least a secondary backup of a lot of that data, but that doesn't mean during the time that they're collecting that data, that attack can't be levied there, whether that's directly through a virus that's inserted into the system in order to scramble data, or even a denial of service attack that attempts to impact the Census Bureau website during those search times when people respond.
Supervisor, before you run, and I know you do have to run, I just want to mention, the question I'm going to ask in a moment is, what, if anything, can our county do about this, since all this is being conducted by the U.S. government? That may be as simple and challenging as communicating as part of our census efforts, things to do, things not to do. But I'm also going to ask for an off-agenda report to our board on this so that all 5 members of the board get the benefit of some of this.
Yeah, and I was thinking at the very beginning of this particular presentation, it would be good, and you're probably already thinking of that yourself, but to have this item as some sort of recurring item here, because otherwise it just feels like and I think you already said that, but I think process-wise, but I don't want to get to the point where we do all this work and all these efforts and we say, yeah, remember what we heard back in September of 2018. We just kind of put it aside, and now we have all these problems. So I'm not sure what we're in a position to actually do as a single county, but we've had some success banding together with birds of a feather in the past on some of these kind of issues, and maybe there's some collective power. I think we've talked to Mr. Campos about that.
Yeah.
Some collective ability to fix some of these anticipated problems before they happen. But that meaning, I think hearing it, I have no problem hearing this every couple of months or every 4 times a year, whatever you think as the chair.
Thank you. So briefly, understanding that we have thoughts to think and work to do in the months ahead, thoughts about what, if anything, our county might be able to do or should do. We are, I think, in a perplexing situation, which is, we've taken steps and allocated funds to exhort people to participate in the process, even as we are sitting here expressing our concerns about some elements of the process. So that has the potential to send mixed messages. Thoughts about how we might proceed and try and make sure that we're playing a constructive role in terms of these privacy and data security issues?
Yes, and I spoke with David Campos during the time period when the Census 2020 project was going through the canvassing phase, and we discussed issues about messaging and people's concerns about their privacy, and a lot of the focus was on marginalized communities and communities predominantly affected by immigrants, that there may be concern with how the government has received their information about their household, especially with addresses or site addresses within the same plot of property. So we discussed that as well as the best approaches to message this particular information. A lot of it revolved around letting them know, both the county, when county supported canvassers go out there to ask people about their information, their addresses, that they can feel assured that that information is going to be protected, and that is relayed to the Census Bureau, and that the Census Bureau is not allowed by law to share that information with other law enforcement entities, with ICE, or with anyone else. So I think the messaging part is really important. One of the other things I spoke with David about is, how can we provide assistance to people who may have questions about it. The Census Bureau does have a hotline where people can call for information. They have websites where they can go for that. Anything, though, that we can do at the county level, perhaps working with David Campos, we can maybe think about some of the best approaches to support people who have concerns about it.
Mr. Williams, I apologize for putting you on the spot, short notice, maybe Mr. Marquez as well, because he was looking relieved there for a moment, so I wanted to make sure they were both. My recollection is that the DACA kids were given some assurances that information they provided would be kept in a particular confidential way, and that information was subsequently shared. Am I misremembering?
No, they were given assurances, and that has been one of the issues in the litigation, and all of the trial courts have basically reaffirmed that that they can raise valid claims regarding the confidentiality of the information. There are concerns that the information may be shared, but I don't believe there's any evidence that it has been.
All right. Well, we're running a little long today anyway, and we're probably not going to sort all this out in the next 5 to 10 minutes. But if I could ask you, Mr. Shapiro and Ms. Christian, to pull together some written notes on this, and it can be relatively concise, but that sort of articulates the concerns that you've shared with us today. And if we can ask you to provide that as an off-agenda memo, which is a public document, and then also give some more thought, working with our census outreach teams, to what we as a county can do, and or, as Supervisor Cortese was mentioning, are there places we should be taking these concerns, articulating these concerns, along with others who might share them. And I've said, for a long time, I work under no illusion that folks in Washington are waiting with bated breath to hear from the County of Santa Clara on these items. That being said, if we don't speak up, we can't be surprised we don't get heard. And if we are smart about how we speak up and find others to join us in that effort, there's more likelihood that there will be public notice, perhaps public expression of concern, and ultimately some response from folks at the federal level. So with that request, we will thank you both for the report. Anything else from anybody either on the line or here in the chambers on this item?
This is Erin Griffey at Prime. I just wanted to add one or two notes about the census and about how to advocate to make sure our issues are heard. Number one is to, as we go about our business, to advocate for full funding for the census through the Appropriations Committee. But I would also note that in 2018, the funding for the census was, I believe, almost doubled from 2017 and to $2.8 billion. And for 2019, the recommended amount is $4.8 billion. So they're already planning for all that has to be done and taking into consideration a lot of these concerns. So I just thought we should keep that in our talking points and on our memos when we're talking to our delegation and appropriators.
Thank you. And for the folks at Prime, and I know you know this, but it may not be top of mind for you on the other side of the country. And staff can correct me if my recollection on the numbers is wrong, but 37% of our county's population is foreign born, if I am remembering the numbers right. And then what that means as well is that, you know, something like 65+% of folks in the county then live in a household where at least one member of the household is foreign born, because that 37% have spouses and siblings and offspring. And so a citizenship question is not simply an academic or theoretical issue in our county. And I do think we need to be mindful of that, as it's certainly not unique to Santa Clara County, but it's a special circumstance that affects Santa Clara County in a way that might be less relevant in other parts of the country. As I say, this is not an abstract or theoretical exercise for our county. And, you know, candidly and fortunately, and I mean that in the best of ways, you know, my colleague has stepped away. Whenever I mention, you know, how do I respond to a constituent at sidewalk office hours, and I get a smile from my colleagues, but I'm sitting here, Ms. Christian and Mr. Shapiro and folks at Prime, asking myself, having held sidewalk office hours this past weekend where folks just walk up and tell me what they think and ask me for information, if I had a foreign national who was lawfully in the country, let alone an undocumented immigrant, and if they said, when I get the census form, should I fill it out? You know, unfortunately, I would pause. And if they more specifically said, I understand there's a citizenship question, should I fill it out? I would definitely have reason to pause. And that's a bad place to be, because we've talked about how important the census is for all the reasons that have already been articulated and that I won't recapitulate. But that's going to require some thought, in my view, going forward about you know, whether or not we can identify additional protections, whether or not we can communicate to our constituents ways in which they can protect themselves. Perhaps that's the most practical line of inquiry. But on that note, I will say thank you once again, and we will then note that the consent calendar has already been approved by a unanimous vote, which takes us to item number 13, which is to adjourn to our next regular meeting of this committee, which is on Wednesday, October the 3rd at 10 a.m. in these same board chambers. Thank you all very much for the conversation today. Very helpful. We are adjourned. We are adjourned.